Okay, so today we're going to talk about pretrial case management. This is one of the most tested on sections in the MBE for the bar exam. So today we're just going to read the chapter and then we'll do a short summary video later. So the first part is going to be the introduction. Part 2 is the general pretrial authority. Part 3 is the effect of the pretrial order. And then we're going to end with Part 4, pretrial case management, summary of basic principles. So David sues Goliath for assault. Goliath fires a timely answer. What happens next? David serves interrogatories on Goliath. Goliath answers a few but objects to most of them. What happens next? Discovery enters its third year. Goliath takes a disposition. What happens next? The answer to all these questions is the same: nothing. The American adversary process was historically party-driven and self-regulating. The judge's role was a passive one until one of the parties asked for her to do something by filing a motion. Judges and their clerks have enough to do without searching the docket, looking for more, although they will dismiss the case on their own initiative if a plaintiff is inactive for too long. We can find out about this in the Federal Rules of Civil Procedure 41B, providing for involuntary dismissal if the plaintiff fails to prosecute. But heavy dockets and the cost of litigation have created pressure for judges to play a more active role in managing civil litigation. We saw in the chapter on discovery tools that in most federal cases, the court is required to enter a scheduling order after receiving the parties' report or consulting with them at a scheduling conference. Federal Rules of Civil Procedure 16B1. Such an order may itself schedule subsequent pretrial conferences. Many courts have adopted local rules and individual judges have issued standing orders requiring such conferences and addressing other aspects of case management. Moreover, before a case goes to trial, the court will commonly hold a pretrial conference to identify the issues for trial, make pretrial rulings for admissibility of evidence, discuss the order of the trial, and sometimes to explore settlement. So the pretrial conference kind of gets things going to see, how the rest of the trial is going to go. The authority in federal court for such case management by pretrial conference and pretrial orders is chiefly Rule 16, which we will explore in Section 2. Under the rule, the final pretrial order typically controls the course of the trial. It may list the claims or defenses that will be litigated there, or identify the witnesses each side will call. If a witness is not listed in the final pretrial order, the court may exclude that witness from testifying at trial. Section 3 discusses final pretrial orders and their exclusionary effect. So 2, general pretrial authority. A federal judge has the authority to issue scheduling orders, but what else can he do to manage a civil case? Rule 16 C2 identifies matters for consideration at pretrial conferences, but how far can the judge go to order parties to attend, consider, and even more, resolve or agree on such matters? So standing order on pretrial conferences, the Northern Division Civil, SD3. A final pretrial conference will be scheduled by the court as soon as feasible after the date for completion of discovery. Okay, notice of such final pretrial conference will be given to all counsel in sufficient time, customarily not less than 10 days, so that they may and they are hereby directed to confer in advance of much pretrial conference for the following purposes. Number 1, explore carefully the prospect of settlement. And number 2, enter into a written stipulation or statement of all uncontested facts. At such final pretrial conference, which shall be attended by attorneys representing all parties who are authorized to enter into such agreements as may be appropriate, presumably the counsel who are to try the case. Counsel shall submit the court the following: 1, written stipulation of statements of the uncontested facts signed on behalf of all parties. Immediately following such final pretrial conference, an appropriate order will be prepared by an attorney for a plaintiff unless otherwise agreed upon at the conference, reflecting the action taken and agreements made at such a conference. In the general form attached hereto, approval of such proposed order shall be obtained from counsel for all other parties by signature thereon, and such approved order will be entered on by the court upon submission, which should not be more than 2 weeks after the conference unless otherwise agreed at the conference. The case will be added to the court's trial calendar. Failure of counsel to appear at any scheduled pretrial conference or otherwise to comply with the provisions of this order may result in dismissal or default as may be appropriate. So if your attorneys don't show up, this could get your case dismissed. 4, the court finds that strict compliance with this procedure generally followed in this division since September 1967 is important to the prompt, orderly, and fair disposition of cases. The counsel will be expected to comply therewith in the interest of sound administration of justice. The court henceforth will not hesitate to impose the sanctions mentioned for willful or careless failure of strict compliance by counsel. So this is Figure 21, excerpt from a standing pretrial order in the Edwards Construction Company. Reading JF Construction Company v. Anderson Safeway Guardrail Court. Rule 83A provides that A, judge may regulate practice in any manner consistent with federal law, the federal rules of civil procedure and the federal rules of evidence, and the district's local rules, federal rule of civil procedure 83A. In the following case, the trial judge used that authority to issue a standing order on pretrial conferences, governing pretrial conferences in its court, the relevant parts of which are shown in Figure 26.1. A standing order applies to all cases, and that the court, while a specific order will be directed just to a particular case. The trial judge held a pretrial conference. At the conference, he ordered the parties to follow stipulation of facts pursuant to the standing order. By stipulating, a party agrees to treat the matter stipulated as an undisputed fact for purposes of the action. When defendant Anderson refused to agree to the other party's proposed stipulations, the court struck its pleadings, dismissed its claims, and entered judgment against it. When the defendant Anderson refused to agree to the other party's proposed stipulations, the court struck its pleadings, dismissed its claims, and entered judgment against it. So they entered judgment against the defendant Anderson. Why did the court order the parties to confer by stipulations? What does Rule 16 require parties to confer? If the court so orders at a pretrial conference, does Rule 16 require parties to stipulate? Did the standing order require the parties to stipulate? If it had, would such an order be authorized under the federal rules? So J.F. Edwards Construction v. Anderson Safeway Guardrail Court, before Castle Senior Court Judge Cummings and Pale Circuit Judges. All right, so J.F. Edwards Construction Company sued Anderson Safeway Guardrail Corporation for damages arising out of a construction project, and Anderson separately sued Westinghouse for damages arising out of the same project. The two federal actions were consolidated. In the consolidated action, Anderson asserted various claims, and claims were made against it. At that conference, pursuant to the district court standing order on pretrial conferences, see Figure 26.1, the parties are directed to file a stipulation of facts by July 1st, 1975, and a pretrial order by August 1st, 1975, each to be signed by the respective parties. Edwards and Westinghouse agreed to a stipulation, but after much give and take, including Edwards' deletion of some proposed stipulated facts by Anderson balked. On January 29th, Anderson's counsel wrote the trial judge amplifying Anderson's reason for refusing to sign the stipulation. Anderson's counsel maintained that Edwards' counsel had deleted 19 specific matters from the stipulation of facts supposedly agreed upon December 22nd, thus causing Anderson's counsel to refuse to execute the stipulation of facts. However, he stated that he would be amenable once again to resolve these matters in a reasonable, prudent, and professional manner. On January 28th, Edwards and Westinghouse filed a motion requesting the district court to enter an order striking Anderson pleading and for other relief. On February 9th, 1976, Judge Morgan also took the following action. All Anderson's pleadings were stricken. Judgment was entered for Edwards on Anderson's counterclaim. Anderson's complaint against Westinghouse was dismissed. Judgment was entered against Anderson on Edwards' complaint, subject to jury verdict on the dollar amount of damages proven in ex parte proceedings. Westinghouse cross-complaint against Anderson was dismissed as moot. On the next day, the district court permitted a jury to render an ex parte verdict against Anderson in the sum of $89,018.66 after hearing the testimony of John F. Edwards Sr., the chairman of the board of Edwards. Anderson's motion to vacate judgments for a new trial and other relief was denied on February 24th, and its notice of appeal was filed on March 11th. In supporting the district judge's draconian orders against Anderson, Edwards and Westinghouse relied primarily on Rule 16 of the Federal Rules of Civil Procedure, Rule 10 of the Rules of the United States District Court for the Southern District of Illinois, Local Rule 10. The trial court standing order on pretrial conferences in Northern Division civil cases standing order. Rule 16 permits a trial court to direct attorneys for the parties to appear before it for a pretrial conference to consider 5 described matters and such other matters as may aid in the disposition of action. Under this catch-all clause at paragraph 3 of Rule 16, now Rule 16C2C, Judge Morgan was clearly within his rights in asking counsel for the three parties to try to stipulate all possible facts. By all means, such stipulation should be encouraged. Yet, on the other hand, nothing in Rule 16 empowers a court to compel the parties to stipulate facts. Similarly, Local Rule 10 does not make it mandatory to stipulate facts. Two sections of the standing order deal with stipulation of facts in the context of a pretrial conference. Section 3A2, in pertinent part, directs counsel to confer in advance of the pretrial conference for the purpose of entering into a written stipulation or statement of all uncontested facts. Counsel for the parties complied with this provision by attempting to arrive at a mutually acceptable stipulation. Anderson's counsel submitted a stipulation of facts to Westinghouse and Edwards, whose counsel refused to agree thereto. Earlier, Edwards had submitted a stipulation of fact to which Westinghouse agreed, but Anderson did not. It is most unfortunate that counsel for the three parties could not at least agree to stipulate to some facts, but Section 3A2 only requires the parties to confer for the purpose of generating stipulation, and the parties clearly did. Section 3B1 of the standing order, however, does not require counsel to submit the written statement of the uncontested facts signed on behalf of all parties at the final pretrial conference. To the extent that this language can be read to mandate that stipulations of fact must be made, it may not stand. On its face, Rule 16 of the Federal Rules of Civil Procedure does not authorize a court to force parties to stipulate facts to which they will not voluntarily agree. Under Rule 83 of the Federal Rules, the District Court's Local Rule 10 and its standing order must be consistent with the Federal Rules of Civil Procedure. As noted in this case, the parties cannot agree on a final stipulation of uncontested facts. Of course, counsel should have been more tractable and stipulated all possible facts to shorten the trial instead of being so intransigent. What's that mean?
Intransigent.
Intransigent, unwilling or refusing to change one's views or agree about something. Intransigent. Okay, intransigent. So it says that, of course, counsel should have been more tractable and stipulated all possible facts to shorten the trial instead of being so intransigent in their respective positions. Yet, even in this posture, the standing order cannot authorize sanctions which are not explicitly authorized by the federal rules. As Moore's treatise As Moore's treatise notes, a pretrial conference may save time and expense, perhaps by leading the parties to stipulate that certain documents will be produced or desired information furnished. 3 Moore's Federal Practice 1616 at 1126, second edition 1974. But we have been cited to no authority showing that a district court has the power to force parties to stipulate facts unless they can agree on the same. Behind the face of Rule 16, a narrowly circumscribed area of power has developed which the judge may employ to compel obedience to his requests and demands relating to the pretrial conference. This power may be founded either upon Rule 41B or upon the inherent power of courts to manage their calendars to have an orderly and expeditious disposition of their cases. Link v. Wabash Railroad Company. Whatever the exact genesis of this power to compel obedience, the key is a failure to prosecute, whether style as a failure to appear at a pretrial conference, failure to file a pretrial statement, failure to prepare for the conference, or failure to comply with the pretrial order. Therefore, Rule 41B, dealing with involuntary dismissal of the inherent power of the district court, do not support the sanctions imposed. Obstreperous.
Obstreperous.
Obstreperous, noisy and difficult to control. Okay, so obstreperous, as the parties refuse to reduce at least some facts to a stipulation, might be obstreperous, as the parties refusal to reduce at least some facts to a stipulation, might be. Anderson cannot be characterized as dilatory to the point of manifesting a failure to prosecute. Obstreperous.
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 Dilatory.
Dilatory. Slow, unhurried, tardy, unpunctual, dilatory.
Dilatory.
I wonder if that's where dilly-dally comes from, dilatory. Okay. Anderson cannot be characterized as dilatory to the point of manifesting a failure to prosecute. While we sympathize with the district court's distress at having to face a trial where the parties have not agreed upon any stipulation of facts, Edwards and Westinghouse have not convinced us that the sanctions imposed upon Anderson were permissible. Although Anderson did not agree to the Edwards-Westinghouse stipulation of facts, it did propose its own stipulation of facts and pretrial order on December 22nd agreed upon a stipulation of facts, which Edwards counsel later revised in terms unacceptable to Anderson. On October 3rd, all parties signed a pretrial order prepared by Anderson and then submitted it to the court. In view of the continuing contretemps between counsel contretemps, minor dispute, contretemps. In view of the continuing contretemps between counsel, the famous Shakespearean stricture, a plague on both your houses seems singularly apt. A restriction on a person's activity.
Stricture.
Stricture. Okay. Between counsel and the famous Shakespearean stricture, a plague on both your houses seems singularly apt. To recapitulate, Rule 16 of the Federal Rules of Civil Procedure does not compel a stipulation of facts so that sanctions or for failure to file one are not available. Of course, the trial court must have the power to make effective a pretrial order within the four corners of Rule 716. But in order, forcing parties to stipulate facts is not authorized by that rule, and the reporter of the Supreme Court's Advisory Committee on the Rules of Civil Procedure has written. So the proper function of pretrial is not to curb the parties or one of them into submission. Rather, the function is to see that the parties of the court are fully acquainted with the case, leaving no room for the tactic of surprise attack or defense, and to uncover and record the points of agreement between the parties and to the end of shortening and simplifying the eventual trial. Note the emphasis of Rule 16 upon the agreements made by the parties as to any of the matters considered. There is here no basis for forcing the parties to replead or restate their legal propositions in terms more limited than the issue framed by the pleadings. Pretrial in purpose and in its most successful use is informational and factual rather than legal and coercive. It may well lead to settlement as the parties come to know their case better, but that must remain an uncoerced byproduct. Okay, Clark, to an understanding use of pretrial, it says, while we applaud Judge Morgan's assiduous efforts to produce an agreed upon stipulation of facts under the Federal Rules of Civil Procedure, judicial compulsion is not allowable in this area. Let's define this word.
Assiduous.
Assiduous, showing great care and perseverance. Okay, so While we applaud Judge Morgan's assiduous efforts to produce an agreed upon stipulation of facts under the federal rules of civil procedure, judicial compulsion is not allowable in this area. Since we hold that Anderson's failure to agree to the Edwards-Westinghouse stipulation of facts did not justify dismissal of the complaint against Westinghouse, it follows that it was improper to enter judgment for Edwards on Anderson's counterclaim and against Anderson on Edwards' amended complaint. Anderson's pleadings having been improperly stricken, it was also erroneous to dismiss Westinghouse cross-complaint against Anderson as moot. The order on the motion to strike pleadings and the judgments of February 9th and 10th, 1976 are vacated, and the cause is remanded for trial pursuant Circuit Court 18. If further discovery or other pretrial matters remain to be completed, the next trial judge should attempt to control any undue rigidity of counsel for any of the parties. Sanctions are often available to counter pretrial recalcitrance, even though not authorized for failure to agree on a stipulation of facts.
Recalcitrance.
Recalcitrance, state of being recalcitrant. Okay. Okay. Obstinately defiant or authority or restraint. Recalcitrant. Defiant.
Recalcitrant.
Sanctions are often available to counter pretrial recalcitrance, even though not authorized for failure to agree on a stipulation of facts. Recalcitrant is the state of being obstinate, difficult to manage, obstinately defiant of authority or restraint, difficult to manage or operate, not responsive to treatment. The subject is required to attempt both to observation and experiment. Okay. Notes and questions, pretrial purpose and authority. Why stipulations? The answer is suggested by the standing order. It directs the parties to confer in advance of the pretrial conference for the purpose of entering into written stipulations of all uncontested facts. The purpose of trial is to try disputed facts. If the parties can agree, stipulate on undisputed facts, it leaves less to be tried and may shorten the trial. Similarly, if they can't agree to the conditions for the admission of some evidence, such as the qualification of an expert to testify or the authenticity of a document, that will also shorten the trial. A good part of the final pretrial conference is directed toward streamlining trial and making it more efficient. Stipulations are but one streamlining device. Identification of the issues and of expected trial witnesses is another. Other purposes of pretrial conferences. While Edwards is concerned with those provisions of the standing order, it applied to the final pretrial conference. Rule 16 is more expansive. After stating 5 broad purposes for pretrial conferences, primarily aimed at what Rule 1 calls speedy and inexpensive determination of an action, the rule lists no less than 16 matters of consideration, which provide a pretty thorough survey of what pretrial management may involve. See Federal Rules of Civil Procedure 16C2. Requiring parties to confer or attend. Could the court require the parties or their lawyers in Edwards to attend a pretrial conference? The standing order certainly assumes so, for it shouts that failure of counsel to appear at any scheduled pretrial conference may result in dismissal or default as may be appropriate. Rule 16 originally stated that the court may, at its own discretion, direct the attorneys for the parties appear before it for a conference. Now, Rule 16F not only authorizes sanctions if a party or its attorney fails to appear at a scheduling or other pretrial conference, but also if the party appears but is substantially unprepared to participate or does not participate in good faith at the conference. Requiring stipulations. If a lawyer can be ordered to attend a pretrial conference and to confer in advance about stipulations, why can't she be ordered to stipulate? I'm assuming it's because they might not have anything to agree about. First, the standing order did not go so far. While it said that lawyers shall submit the written stipulation of the parties, this arguably only requires submission if there is a stipulation. Second, had the order required stipulation, it would have gone too far, well beyond Rule 16. The version of Rule 16 then in effect referred just to the possibility of obtaining admission of facts of documents, which will avoid unnecessary proof. Okay, Rule 16C3, emphasis added, even the more ambitious amended rule that has since been adopted lists stipulations about facts and documents to avoid unnecessary proof, simply as a matter of consideration and not as a binding requirement. Rule 16C2C, because the standing order that mandates stipulation would be inconsistent with Rule 16 itself, it would be invalid. Just as local rules must be consistent with the federal rules, so must standing orders or specific orders regulating practice before a particular judge, according to Rule 83. See the discussion of hierarchy of authorities in Chapter 2. The reason that Rule 16 does not require stipulations was well stated by Judge Clark, the father of federal rules. The purpose of pretrial is to acquaint the parties and the court with the issues, to uncover points of agreement, and thus to shorten and simplify an eventual trial, not to club the parties into submission. Clark separate 29. FDR at 456. If pretrial management is handled diplomatically and creatively by the judge or magistrate, a byproduct can be a streamlined trial or even settlement, but that byproduct must remain uncoerced. To put it differently, Anderson had a right to try the facts it disputed and could not be forced to stipulate them. Requiring settlement. The same reason that Anderson has the right to try disputes of facts supports the conclusion that a court cannot use the pretrial conference as a club to force a party to settle. To be sure, the rule clearly identifies facilitating settlement as a purpose of pretrial and even makes consideration an alternative dispute resolution procedures proper in some cases, but it does no more. No party can be forced to settle rather than try its dispute. Management by magistrate. So far, we have assumed that the case is managed by the trial judge. Federal district court judges are appointed under Article 3 for life. A life appointment gives the litigants before a federal judge some assurance of her independence, though of course no guarantee. In practice, however, federal district court judges often assign pretrial case management, primarily the management of discovery, to magistrate judges. Magistrate judges are also federal judges, but they are appointed only for 8-year terms. Although every magistrate judge also tries to make independent decisions, a term appointment does not provide the same assurance of independence that a life appointment provides. Theoretically, then, if magistrate judges were allowed to make the same decisions in civil actions as Article 3 judges, parties to the actions could be denied a measure of independence that the Article 3 life appointment was intended to promote. Yes, so the whole point of having judges that are appointed for life is that they have independence. They're not worried about their job, even though there's no guarantee. But in practice, many of the federal district court judges often assign pretrial case management to magistrate judges who only have an appointment for 8 years. So the magistrate judges were allowed to make the same decisions in civil actions as Article 3 judges. Parties in the action could be denied a measure of the independence that the Article 3 life appointment was intended to promote. So because of this in practice, the magistrate judges handling it, it can be taken away some of the independence that the judges were supposed to have by having life appointment. As a result, Congress has tried to limit the kinds of decisions that can be assigned to magistrate judges. First, it forbids magistrate judges from trying cases unless all parties consent. So this is Title 28 of the U.S. Code, Section 636C in Federal Civil Procedure, Rule 73. Second, it provided that a federal judge may designate a magistrate judge to hear and determine any pretrial matter pending before the court, except the motion for injunctive relief for judgment on the pleadings for summary judgment to dismiss or to permit maintenance of a class action, to dismiss for failure to state a claim upon which relief can be granted, and to involuntarily dismiss an action. A judge of the court may reconsider any pretrial matter under the subparagraph A where it has been shown that the magistrate judge's order is clearly erroneous or contrary to law. So a federal judge may designate a magistrate judge to hear and determine any pretrial matter pending before the court except the following: a motion for injunctive relief, for judgment on the pleadings, for summary judgment, to dismiss or to permit maintenance of a class action, to dismiss for failure to state a claim upon which relief can be granted, and to involuntarily dismiss an action. So a judge of the court may reconsider any pretrial matter under this subparagraph A where it has been shown that the magistrate judge's order is clearly erroneous or contrary to law. So Title 28 of the U.S. Code, Section 636B1A, the trial judge, however, can assign the accepted motions to the magistrate for recommendation, which the trial judge can accept or reject. Okay, so then in Section 636B1B through C, thus the statute distinguishes between ordinary pretrial matters, which a magistrate can decide subject only to review or on objection by a party by the district court judge for clear error or mistake of law, and certain motions on which a magistrate judge may only recommend a decision that the district court judge is free to accept or reject. Federal Rule 72 therefore also distinguishes between the former, which it calls non-dispositive matters, and the latter, which it calls dispositive motions. Let me get this pronounced, or let me see how this is pronounced. It matters that can be deposed, I don't know. Directed toward or affecting disposition.
Dispositive.
Directed toward or affecting disposition of a case. Disposition.
Disposition.
Prevailing tendency, mood, or inclination, temperamental makeup, the tendency of something to act in a certain manner given certain circumstance. The act or the power of disposing, or the state of being disposed, such as administration, control, final arrangement, settlement. Okay, transfer to the care or possession of another, the power of such transferal, orderly arrangement. So these are the definitions for dispositive motion. Okay, so the effect of the pretrial order. As the final pretrial conference approaches, the court may require parties to exchange final pretrial briefs, identifying their claims and defenses, identifying issues being tried, listing proposed witnesses and exhibits, and objecting to the opposing parties' witnesses and exhibits. The court will often craft a final pretrial order on the basis of these briefs, and the final pretrial conference constituting a trial plan, including a plan to facilitate the admission of evidence. Federal Rules of Civil Procedure 16E. The final pretrial order supersedes the pleadings, which may well have contained claims or defenses that the parties have decided to drop after discovery, and can be modified only to prevent manifest injustice. Okay, so the final pretrial order supersedes the pleadings because some contain claims or defenses of the parties have decided to drop after discovery, and it can only be modified only to prevent manifest injustice. Reading Davey v. Lockheed Martin Corp. In the following employment discrimination case, the defendant sought to modify the final pretrial order to add an affirmative defense of good faith compliance on the Friday before a Monday trial. Why did the trial court refused to modify the pretrial order? What was the effect of the trial court's refusal? How could the trial court have addressed this concern about the 11th hour addition of the affirmative defense without excluding the defense? Davey v. Lockheed Martin Corp. Okay. Susan Davey brought this employment discrimination action against her former employee, Lockheed Martin Corporation, alleging LMC discriminated against her on the basis of gender and retaliated against her for complaining about the discrimination when LMC selected her for layoff during a reduction in force. A jury trial resulted in a verdict in favor of Davey on one of her retaliation claims. In accordance with the jury's verdict, the district court awarded Davy compensatory damages of $50,000 and punitive damages of $200,000, and further entered judgment in favor of Davy for back pay of $112,800, front pay of $36,000, and attorney fees of $65,610, plus prejudgment and post-judgment interest. LMC appeals the verdict in favor of Davy on the retaliation claim, contending the district court erroneously denied it the opportunity to present a material aspect of its case to the jury, which led to an unfair award of punitive damages. As regards the punitive damages award, LMC contends the district court erred in not allowing LMC to present a material aspect of its case to the jury, good faith compliance with Title VII. On Friday, August 20th, 1999, the parties filed an amended pretrial order to reflect several additions, but were unable to agree on one addition: whether LMC could assert the affirmative defense that it could not be liable for punitive damages because it made good faith effort to comply with Title VII. According to LMC, the newly proposed affirmative defense was based on the recent decision in Colstad v. American Dental Association. The amended pretrial order was filed with a space for the trial court to mark whether it granted or denied LMC's request to add the affirmative defense. At the beginning of the trial on Monday, August 23rd, 1999, prior to selection of the jury, the court stated it would not allow LMC to assert that it made a good faith effort to comply with Title VII as a defense to punitive damages because allowing the defense would be fundamentally unfair to the plaintiff. The court noted the defense was factually intensive and the plaintiff did not have an opportunity during the discovery phase of the case to take discovery as to whether or not there's a response to that defense. A pretrial order which measures the dimensions of the lawsuit. I love that. A pretrial order which measures the dimensions of the lawsuit, both in the trial court and on appeal, may be modified only to prevent manifest injustice. Federal Rules of Civil Procedure 16E, the party moving to amend the order bears the burden of proof, the manifest injustice that the party moving to amend the order bears the burden to prove the manifest injustice that would otherwise occur. See Koch v. Koch Industrial, Inc. Okay, the purpose of the pretrial order is to ensure the economical and efficient trial of every case on its merits without chance or surprise. See Hull v. Chevron USA, Inc. All right, because the issues and defenses of the lawsuit are defined by the terms of the order, total inflexibility is undesirable. We reviewed the denial of a motion to amend the pretrial order for an abuse of discretion. A district court can abuse this discretion when it bases its ruling on an erroneous conclusion of law. Kiowa Indian Tribe v. Hoover, or fails to consider the applicable legal standard. Olander v. Larson. Colstad was decided 2 months prior to commencement of this trial. The original pretrial order was filed a year and a half prior to the Colstad decision. As stated, the district court did not allow LMC to benefit the benefit of the Colstad defense because Davy had not had the opportunity to conduct discovery on the issue, and therefore allowing the defense would be fundamentally unfair to the plaintiff. We consider the following factors in a challenge to the district court's denial of a motion to amend the pretrial order and resulting exclusion of the issue. Number one, prejudice or surprise to the party opposing trial of the issue. Number two, the ability of that party to cure any prejudice. Number three, disruption by inclusion of the new issue. And number four, bad faith by the party seeking to modify the order. Koch 203 at 1222. We also take into consideration the timeliness of the movement's motion to amend the order. Prejudice, surprise, timeliness. The district court's denial of LMC proposed amendment rested entirely on prejudice to Davy. Davy argues the district court's decision was correct because the request was contained in the amendments to the pretrial order filed on Friday before trial was to begin the following Monday, and she could not have conducted any meaningful discovery over the weekend while also preparing for the trial. LMC responds that Davy could have moved to continue the trial. In Moss v. Fieldmeyer, the court affirmed the district court admission of testimony from two expert witnesses, either not listed or not fully described in the initial pretrial order. The district court permitted defendant to amend the pretrial order to add Dr. DeYoung as an expert witness and to expand the scope of Dr. Evans' testimony on the morning of the trial. The court reasoned that the opposing party, the plaintiff, was not prejudiced or surprised by the additions because both doctors were designated as witnesses in the amended pretrial order. Dr. DeYoung was designated, or is it DeYoung? I don't know, was designated as an expert more than 2 weeks before the trial. The plaintiff received a summary of both doctors' reports prior to the trial testimony. Both doctors were available for discovery prior to testifying, and the plaintiff, at her option, disposed Dr. DeYoung, but did not dispose Dr. Evans. The court contrasted the facts in Moss with the facts in Smith v. Ford Motor Company, where the prejudice factor was found to weigh in favor of the opposing party. In Smith, the surprise testimony was presented during the trial. One of the plaintiff's witnesses, Dr. Feston, was listed in the pretrial order as a treating physician. However, to the defendant's surprise, Dr. Feston was allowed to give an expert opinion on the cause of the plaintiff's injury. Counsel for the defendant was granted only a 10-minute recess to prepare a cross-examination. Thus, we found that defendant was prejudiced by the new expert testimony. The court noted, however, that if Ford had been apprised in advance of Dr. Feston's testimony, it could have taken his disposition, discovered the article, and been well prepared at trial to cross-examine him. Okay, in Summers v. Missouri Pacific Railroad System, this court reversed the denial of a motion to amend a pretrial order to add an expert witness, relying on the fact that the motion was filed prior to trial and therefore trial would not be disrupted. Thus, the timing of the motion in relation to the commencement of the trial is an important element in analyzing whether the amendment will cause prejudice or surprise. Here, the amended pretrial motion was filed on Friday, August 20th, and trial was beginning Monday, August 23rd. Trial had not started and therefore could not have been disrupted. However, LMC's motion to amend was untimely given the 2-month period that had elapsed between the filing of the COSTED decision and the filing of LMC's motion to amend the pretrial order. Ability to cure. Closely related to the prejudice and surprise factor is whether the opposing party had the ability to cure any prejudice or surprise caused by the amendment. For example, in Smith, we found that this factor weighed in favor of the defendant because after the expert witness gave surprise expert testimony, the defendant counsel had only 10 minutes to prepare for cross-examination and review the witness's use of empirical study not disclosed during discovery. If, however, the motion to amend is made prior to trial, it is more easily found that the opposing party could cure any prejudice. See Summers. Okay. Finding second factor weighed in favor of granting the plaintiff's motions to amend to add 2 expert witnesses because motion was filed 80 days prior to trial, giving the defendant time to conduct discovery. See also Moss 979. All right. Holding, whereas Ford only had 10 minutes to prepare for cross-examination. Moss had over 2 weeks to prepare for Dr. DeYoung's cross-examination and 8 days to prepare for Dr. Evans' cross-examination, during which time in each instance, Moss had their respective reports. Under these circumstances, we hold that Moss's ability to cure was not significantly impaired. LMC argues Davey easily could have cured any prejudice or surprise by moving to continue the trial. See Hull v. Chevron USA, Inc., stating that if opposing party was surprised by new theory of recovery first discussed in plaintiff's opening statement, it should have moved for a continuance of the trial with sufficient support to satisfy the trial court that additional time was needed to meet the change in theory. Davey responds that a continuance would have prejudiced her because of the availability of fading memories of the witnesses. She reasons that she would have been forced to choose between having the ability to obtain discovery on the new affirmative defense and having her case tried within 3 years of the day that she filed her complaint. She reasons that she would have been forced to choose between having the ability to obtain discovery on the new affirmative defense and having her case tried within 3 years of the date she filed her complaint. Disruption. The third factor to be considered is whether the amendment to the pretrial order would disrupt the orderly and efficient trial of the case or other cases in court. In Smith, we concluded this factor did not weigh in favor of amending the pretrial order because the challenge testimony first was revealed in the midst of the trial. Adjournment of the trial for dispositions would have resulted in significant disruption. However, if the motion to amend is made prior to trial, no disruption of an ongoing trial is threatened. Stating no disruption of trial threatened because additional expert witnesses and their respective reports were made available to plaintiff prior to testimony. In this case, a continuance might have been necessary so Davy could conduct discovery on the cost of defense. But because the trial had not started when the motion to amend was made, disruption of the trial process would have been minimal. In its reply brief, LMC states that Davy had already disposed most of the witnesses who would have testified regarding LMC's good faith compliance with Title VII. Therefore, redeposing these witnesses on the limited issue of good faith compliance would not have been a lengthy process. We acknowledge a continuance may have caused disruption of other cases scheduled for trial on the court's docket. Bad faith. Finally, the court must consider the bad faith or willfulness and failing to comply with the court's order. In this case, the district court at the time of denying LMC's motion stated, I am not criticizing the defense because COSTAT wasn't issued until June 22nd, 1999. There is no evidence LMC acted with any bad faith or willful disregard of the order. Instead, it merely wanted to amend a pretrial order to reflect a defense recently set forth in a Supreme Court opinion. While the untimeliness of LMC's motion weighs against LMC, the other factors weigh in favor of allowing LMC to amend the pretrial order to assert its defense to punitive damages. We conclude the district court abused its discretion in not allowing LMC to assert its defense and vacate the jury's punitive damage award and remand for a new trial limited to the issue of punitive damages. Notes and questions, final pretrial orders. Reliance, interest, and final pretrial orders. The trial court denied the defendant's request to modify the final pretrial order because it would be fundamentally unfair to the plaintiff. Why? The purpose of the final pretrial order is to formulate a trial plan that permits an efficient trial of the merits without chance or surprise. Knowing the issues and evidence beforehand reduces the influence of chance or surprise. Of course, the pleadings are the initial device for giving notice of issues. Discovery helps uncover the evidence, but the final pretrial order supplants both in taking the last pretrial cut at the issues, claims, and defenses, and often in identifying the witnesses and exhibits. Therefore, a party can ordinarily rely on the final pretrial order as it makes its game plan for the trial. Davy had banked on this order in preparing her case, and the last-minute addition of a brand new fact-intensive defense on which she had no prior opportunity for discovery would upset that reliance interest and therefore be fundamentally unfair, reasoned the trial court. 2. Rule 16E's unspoken exclusionary rule. Rule 16E is silent about the effects of a final pretrial order on attempts to litigate claims or defenses or to introduce witnesses or exhibits that were omitted from the order. But because Rule 16D states that any pretrial order controls the course of action unless the court modifies it. And Rule 16E permits modification of the final pretrial order only to prevent manifest injustice. The effect of such omissions is that the omitted matter or witnesses can be excluded from the trial. The final order controls the claims, defenses, witnesses, and exhibits that can be offered at trial, and those omitted or waived. There are hundreds of cases like Davy, Moss, and Smith discussed in this opinion, in which a party attempts at trial to offer matter outside the final pretrial order. Why so many? We can think of several possible reasons. One is that the lawyers were simply negligent and either overlooked the omission or just forgot the omitted matter. The preparation of a pretrial order requires careful attention and review by the parties and their attorneys. As the trial date approaches, the frenzy of preparation spikes, and even good lawyers may overlook something. Another reason is that when the trial goes badly and a party's claim or defense fails, the lawyer may try to salvage the outcome by trying to substitute an omitted claim or defense that the trial record might support. Last, the lawyer may be trying to win by chance or surprise. A witness may have been omitted on purpose in order to avoid pretrial discovery of the witness and to ambush the opponent in trial. Of course, this is unfair and violates the spirit of the rules, which accounts for the controlling effect usually given the final order. The ambusher is gambling that the court will allow the witness to testify to avoid manifest injustice. We are shocked to think that litigation by ambush is going on here. Okay. Satisfying the manifest injustice test. It may be that suspicion of ambush evidence contributed to Rule 16E's demanding test for modification. Understandably, it focused primarily on prejudice and surprise of the opposing party, who, after all, is entitled to rely on the final pretrial order. But the extent of prejudice depends on whether there is time for that party to meet the new matter. Timing affects the ability to cure. A motion to modify an order to add a defense that is made several months before trial may permit reopening of discovery to depose the new witness or collect more evidence to meet the new defense. On the other hand, final pretrial orders come as close to the start of the trial as reasonable. Rule 16E referring to the time of final pretrial conference. So sometimes the only cure is continuous. Why wasn't a continuous a sufficient cure? In Davy, according to the plaintiff, postponement of the trial could affect the availability and memory of witnesses and would certainly postpone even further the remedy to which she claims she is entitled. It would also have an impact beyond the parties in that it could disrupt the court's trial calendar. Here, the Court of Appeals seems to us a bit saying, I forget how you pronounce this word. Marked by eager hopefulness, confidently optimistic.
Sanguine.
Here, the Court of Appeals seems to us a bit sanguine in concluding that a modification would not disrupt the trial schedule to start 3 days later, though it did acknowledge that a continuance may have caused disruption of other cases scheduled for a trial. Sanguine. Okay, sanguine. Here, the Court of Appeals seems to us a bit sanguine in concluding that a modification would not disrupt a trial scheduled to start 3 days later, though it did acknowledge that a continuance may have caused disruption of other cases scheduled for trial on the court's docket. Of course, it is logically impossible to disrupt a trial when it hasn't yet started, but it is more than likely that any delay of the trial to allow plaintiff additional time to meet the late added affirmative defense will wreak havoc on the judge's schedule. Still, the trial court must also consider why a party seeks modification to the order and the prejudice of the opposing party if modification is denied. Here, the reason for modification was a Supreme Court decision that recognized the affirmative defense a year and a half after the final pretrial. Here, the reason for modification was a Supreme Court decision that recognized the affirmative defense a year and a half after the final pretrial order. Clearly, the employer was not acting in bad faith in raising a new matter, although it strangely waited 2 months after the decision to do so. Modifying a final pretrial order versus amending the pleadings at trial. Suppose an objection is made at trial to the proffer of matter outside the pleadings. Look this up. To present for acceptance, tender offer,
proffer,
proffer. I said it right. Okay. Suppose an objection is made at trial to the proffer of matter outside the pleadings and outside the pretrial order. Rule 15b permits amendment of the pleadings. When doing so will aid in presenting the merits and the objecting party fails to satisfy the court that the evidence will prejudice the party's action or defense on the merits. Should the court apply this standard or the manifest injustice rule in 16E? Although the manifest injustice standard sounds stiffer, some courts have held that Rule 15B controls that it implies controls as it applies later in time than the final pretrial order. Asserting that unbending adherence to Rule 16 stiff standard would frustrate policy favoring liberal amendment. It is unlikely that the pretrial order under Rule 16 was intended to make the pleadings and therefore Rule 15 obsolete. Yet, since both rules consider prejudice to the opposing party, it may make little practical difference which test the trial judge uses in many cases. Several circuits require trial judges who are asked to modify a final pretrial order to consider prejudice to the opposing party, the ability of the moving party to cure the prejudice, the effective modification on the orderly and efficient trial of the case, and the movement's bad faith and willingness and failing to comply with the pretrial order. These factors do not seem materially different from those the court considered in allowing Amendment Rule 15A2 or 15B. Pretrial case management summary of basic principles. Rule 16 provides broad authority to district judges and magistrates acting on assignment from judges to manage civil cases by holding pretrial conferences and issuing scheduling orders and other pretrial orders. Federal judges have authority to require the attendance and good faith participation of parties and lawyers at pretrial conferences, but they lack authority to require parties to stipulate to facts or to settle claims. Parties are entitled to try the issues and cannot be coerced by pretrial orders to forego trial. A pretrial order controls the matters to which it applies unless the court modifies the order, but a final pretrial order governing the plan of trial can be modified only to prevent manifest injustice. Thus, witnesses, exhibits, claims, or defenses that are omitted from a final pretrial order will typically be excluded from trial unless the proponent of the omitted matter carries its burden of showing that it will be substantially prejudiced from the exclusion, that any prejudice of the opposing party from allowing modification and inclusion of the omitted matter can be cured or alleviated. The modification of the order will not disrupt the court calendar and that it has acted in good faith. A pretrial order controls the matters to which it applies unless the court modifies the order, but a final pretrial order governing the plan of trial can be modified only to prevent manifest injustice. Thus, witnesses, exhibits, claims, or defenses that are omitted from a final pretrial order will typically be excluded from trial unless the proponent of the omitted matter carries its burden of showing that it will be substantially prejudiced from exclusion, that any prejudice to the opposing party from allowing modification and inclusion of the omitted matter can be cured or alleviated. The modification of the order will not disrupt the court calendar and that it has acted in good faith. And that is chapter 26, pretrial case management. My watch told me that my heart was beating fast because of the rate to which I was reading, I'm sure. So there you have it, pretrial management. What do you think? I don't know. We're going to have to deep dive into this more, but this will allow me to listen to it several times to really understand everything. And there's a lot of stuff we haven't read yet about discovery and entering evidence and all those things that go to pretrial motions. However, I really did find it interesting that you want to try to get rid of all the issues that you agree on first. That makes sense to me, just in anything. It's like, why should you spend time going over the things you already agree? And sometimes you don't realize that there are things that you agree on. So this provides an opportunity to try to reach a more equitable decision, I guess, or see if there is an opportunity to settle or for alternative dispute resolution. So I like it. All right, so this is Devaney from Legally Noir, Legally Ravenhead, signing off. And for the next couple weeks, we will be talking about pretrial for the MBE, studying for the bar exam.